Well, now let's turn our attention to Georgia's investigation into 2020 election interference. The first few of the 19 co-defendants charged for attempting to overturn the result have surrendered at the Fulton County Jail. More are expected to follow later today, with former President Trump set to turn himself in tomorrow. Joining us now on this from Atlanta is NBC News correspondent Vaughn Hilliard. We also have NBC News legal analyst Danny Ceballos. Good morning to both of you, Vaughn. I will start with you there on the ground because two more people did surrender overnight. Tell us about their alleged roles in this. And we also understand that Trump's former lawyer, Rudy Giuliani, also one of these defendants, expected to follow suit later today, which of course will be a big moment, right?
Right, Savannah. In the depths of the middle of the morning overnight, you had two more of the 19 co-defendants come in to the jail here and turn themselves in for the official booking process. The jail is open 24 hours, and there's a little bit less of a line if you come in the middle of the morning, and that's what David Schaefer, the former Georgia GOP chairman, did. He was at the forefront of gathering the so-called fake slate of electors on behalf of Donald Trump, as well as Kathy Latham. Kathy Latham was one of those fake electors, but she was also the former chair of the Coffee County GOP, who helped coordinate with an outside firm to come in and allegedly tamper with Dominion voting machines inside of that county. For Rudy Giuliani, we expect him to be here in Fulton County as he works out the terms of his potential bond and surrender here. Each of these defendants have until the close of business Friday. That is a deadline set up by District Attorney Fani Willis to come surrender. Ultimately, arraignment is going to be slated for each of these individuals come September, though.
Danny, let's bring you in here and talk about the big one that we might see tomorrow. Trump expected to surrender then. Here's the thing, though. He's set to be released on a $200,000 bond after agreeing to this set of conditions, these stipulations that we're seeing on the screen right now. This has to do with intimidating other defendants and witnesses. Walk us through these and what happens if Trump does violate these rules.
This is a standard order or a standard agreement in the sense that, defendants typically should not be intimidating witnesses. But the challenge here is how do you apply that to somebody who's running for office when so many of the people who may be potential witnesses are people that a potential candidate for the presidency almost is required to lash out against. And here's a typical example I've thought of along with the great Chuck Todd is imagine the president is standing on the debate stage and he turns to Mike Pence, who could be a witness against him in arguably two of these cases, and he calls him a rat or a snitch. This is exactly the kind of language that state prosecutors and federal prosecutors go after people for when they charge them with intimidating witnesses. So look at how broad this language is. Could be any witness, including but not limited to. Beware, folks, language like including but not limited to. That including then is essentially nullified. It could mean anybody, any victim, anything against the community or to any property in the community. Anything that gets people out of their house and maybe writing on a picket sign or pushing a candle through a paper plate for a vigil then has the potential to become something that is dangerous or intimidation or virtually anything. So this is really problematic for Trump, even though, look, his attorneys negotiated that. It's definitely they got the least onerous, the least, restrictive that they could. But this is going to be a problem for the president, former president.
So then, Danny, do we have any idea? Like I said, he's going to be out on bond. If he were to do one of those things that you just described, what happens?
Here's what I picture happening. I picture prosecutors watching him closely and erring on the side of safety and going into court whenever they think he's doing something that's arguably intimidation. But then that's part of their victory, because every time they go back to court, they're going to fatigue some judge who, after a certain point, is probably going to start thinking, look, he should just stop talking. This is wasting court resources. I'm just going to fine him. And then, of course, the way this typically works is that it's incremental. Maybe you start with fines, but at the end of the road, you can incarcerate a defendant for violating some of these orders.
All right, Vaughn, let's bring you back in here because I do want to ask about a couple more co-defendants that we saw surrender yesterday. Trump's former lawyer, John Eastman, and bail bondsman Scott Hall. What happened there?
Right. Both of these men were the first to turn themselves in. The processing for John Eastman, who was one of those lawyers who was advising Donald Trump and is alleged to have been at the forefront as well of organizing the fake slate of electors in multiple states around the country. He did go in for this booking. He told our own Ali Vitale that he still believes the election in 2020 was fraudulent and that Donald Trump, in fact, won. I want to let you listen to him, as it's clear that he intends to very likely plead not guilty. Take a listen to a little bit of what he said.
My legal team and I will vigorously contest every count of the indictment in which I have been named, and also every count in which others are named. I am confident that when the law is faithfully applied in this proceeding, all of my co-defendants and I will be fully vindicated.
Do you still think the election was stolen?
Absolutely.
Absolutely. Still.
No question. No question in my mind.
Sir,
And this is going to be the story of these 19 defendants, including Donald Trump, is the extent to which they stick together or which potentially others may plead guilty and work with prosecutors here. But there are a lot of question marks. This is going to be expensive legal defense for each of these co-defendants. And as they each come in for their surrendering and booking process, this is just the beginning of what could be a long process ahead of potential trial.
Absolutely. And we know, Vaughn, you'll stay on it, and we'll, of course, have this coverage throughout the day as people potentially continue to surrender. Danny, quickly, before I let you go, I do want to switch gears here. We have some new developments in the classified documents case. So a court filing yesterday revealed that a key witness provided new information that implicated Trump and his two co-defendants. This is after switching lawyers. So the filing showed that he changed his testimony in July. That was just weeks before special counsel Jack Smith updated the indictment. How significant is that, and how common is that for witness testimony to change or for them to retract it?
Witness testimony changes. Sometimes it changes before they've even testified and after they've spoken to federal agents, in which case they may have committed a crime. That's Section 1001, false statements, doesn't require sworn testimony. But the point is, witnesses who find themselves in a bit of a legal jam have a tendency to massage the truth. And they don't realize that by the time any federal agents are asking questions, they usually already know the answers. They're pretty much seeing whether you're going to try to lie to them. So sometimes witnesses make it all the way to the grand jury room and give false testimony there. So it isn't that unusual for witnesses to lie. It's not that unusual for witnesses to perjure themselves. But what's really interesting here is that you have a potential conflict of interest. And arguably, according to the government, it's an actual conflict of interest where you may have an attorney who formerly represented a witness who may testify against that attorney's now client. So that is an uphill battle in fighting a conflict of interest challenge by the government. It looks to me like the government might have the edge here. This is the conflict of interest. This is seems pretty clear under the existing case law.
All right, Danny Savalas, Vaughn Hilliard, thank you both so much.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.